hold harmless indemnification agreement, common law copyright notice, W-8-VEN affidavit of your non-resident alien status as it relates to the United States and the Internal Revenue Code and all those different things, all those different language. So there's a lot of clarification. By the time it's all said and done, there's approximately 30 to 34 pages, depending, give or take a page. I had one guy the other day say, "Oh, well, you did my filings and there's only 31 pages on it." Yeah, because, and I think I put out there somewhere 33 was the number because some people it's 33, some people it's 29. Listen, sometimes you can fit the text on 2 pages and sometimes it bleeds over to 3 pages because you don't have enough room to fit it. You put an extra, you put larger size text, you put extra spacing. Okay, so the exact number is not the point, but the content on the pages, right? The content on the pages and the number of, there's probably 12 affidavits in there, is what matters. And as long as you have all the content on the pages, when we file them, it takes approximately 30 or so pages of filings on your UCCs, and about 2 of them is your common law copyright notice. So anybody utilizing and acting as administrator, trustee,
Eventually we get there, and once we do get there, it is what it is. We get there. A lot of folks are definitely trying to get in, so as they try to get in, I'm gonna try to do my best to give everybody what they need in its capacity. I'm gonna start out talking about a few things in accounting, a few things in insurance. I'm going to go into trust implementation. I'm going to make sure that compliance officers get exactly what they need when it comes to implementation. Sometimes this information for new people becomes not incumbent. They just kind of are looking at things from a certain perspective. And when looking at things from a certain perspective, you may have to do the following. Let's see, for instance, let me now take, okay, everybody's coming in. I know what it is. I'm probably going to have to, I'm going to log out and log back in so my audio is clear. So just bear with me because I want you guys to hear everything that I'm talking about. So bear with me because I'm coming. Just let me get it right.
Welcome and thank you for choosing freeconferencecall.com. You're helping people around the world communicate for free. There are 3 participants in the conference.
All right.
Please announce yourself.
Here we go. Here we go. Maybe I'm coming in loud and clear. Yeah, I'm getting a thumbs up. Now I'm good. Now I'm good. Let's see. Let's check my audio over here. Beautiful, beautiful. All right. Here we go. Now let's bring in what I was saying earlier. I'm going to do my best to try to give everybody what they need in its capacity. But man, look, these are exciting times to be alive, and there's a lot of things one need is actually ready to implement. Now, I'm gonna take a stab at implementation, but from a kind of a granular perspective, meaning that I want to show you in real time how to be efficient and effective in implementation. You're gonna need this material. So if you don't already have the materials I'm gonna be referring to, without this material, you're at a great disadvantage. In my opinion, you might be in your own way with trying to get certain things done, because we're going to spend a tremendous amount of time going over stuff that if you had the reference material, we can actually get into the actual cases themselves. And I'm actually I'm gonna do this in real time so some of you guys can actually see this. All right, so let's do this. I'm going to share my screen. Screen's being shared. Boom. All right, my screen's being shared. Now I'm finna go to my trusty number 4 here, because I got number 4 right here. So I got another shared. I'm gonna be sharing with everybody else that's on the other side of it. And I'm gonna share with you guys my actual chat. All right, so one aspect you guys see my ChatGPT. Everyone else, you guys are seeing how I'm getting this stuff all queued up and loaded up. Let me see here. I might be able to bring in ChatGPT in this as well. Let me see. Is it gonna let me select an item for ChatGPT? Let's see. Is it? Yeah, it'll do it. Beautiful. All right, boom. Now you guys see it. All right, you guys are staring at my ChatGPT, right? I'm going to show you the power of this thing, because a lot of folks, you really don't understand how to make this thing applicable unless you really rock with it. Now this right here, I asked ChatGPT to write me a mock case using a particular voice and style. I said, write a mock arbitration case using voice style guide using legalese to describe the explanations. Basically for the plaintiff, which would be Bezel Bay, who is seeking an award in the form of a K-1 disbursement for the defendant, DEF Trust, for failure to comply with arbitration clauses, and I gave a list of different clauses and UCCs. This is the command that I put inside of ChatGPT. So what I'm going to do in real time is I'm going to copy this again, and I'm going to implement this. And I want you to pay attention, because if you listen long enough, you'll learn something. Paste that back into ChatGPT, and I'm gonna have it go run that scenario. Now, I already prompt a question for it to run. And it's running it now as we speak. You can see the ChatGPT is now running the mock case. Now, I don't know about you, but having this capability of taking a scenario and having an algorithm give me a simulation takes what we do to a whole different level. And a lot of individuals who aren't really savvy in this tech, or they're just simply not applying themselves, because see, there's 4 basic aspects that I want you to focus on when doing, and because I get this all the time, Mr. Bay, how should I do my summaries? How should I be doing noting and minuting? Well, this is a pretty good template that you can use. It has the first part where it talks about the case summary, Second part, where it gives you the factual background. Then you have the claims, relief sought, and last but not least, it gives you relevant legal definitions. Oh, it's not done yet, so let me finish hitting the play button so it can fast forward and get the rest of this thing laid out. So it has like 5 basic parts when you're doing noting and minuting. Now, if you got questions, I want you to press 9-4 and I can bring you on and I can get real specific with this thing. Basically, it says this is a mock arbitration case, does not represent any actual legal dispute. But this thing helps me when informing you of format. It helps me instruct you guys in terms of implementation. Like, I'm just gonna lay it out to you. You know, I asked it to give me a mock case using these legalese to describe the definitions and explanations. I basically made Bezel Bay the plaintiff who was seeking an award in the form of a K-1 disbursement from the defendant, DEF Trust, for failure to comply with the arbitration clause using duty of care, contractual limitations, general intangibles, on demand, registered form, remedy of breach of collateral, remedy of indemnity, right of reimbursement, rights of required indemnity, secured party, and I gave them references such as where this information was at and the UCCs that were affiliated. And it literally took that data and it gave me in the case summary. In this arbitration case, the plaintiff Bezel Bay trustee seeks an award in the form of a K-1 disbursement from the defendant DEF Trust based upon the defendant's failure to comply with the arbitration clause. The plaintiff relies upon the legal principles including the duty of care and the contractual limitations as prescribed by UCC 7204. The plaintiff also invokes the concept of general intangibles as defined in Black's Law Dictionary 6th edition, along with the definitions of on demand and registered form found in Black's Law 6th edition and UCC 8102, respectively. Furthermore, the plaintiff seeks remedy for breach of contract in accordance with UCC 2-701 and the remedy of indemnity as outlined in UCC 5-115. The plaintiff asserts the right of reimbursement is provided by UCC 5-114 and indemnifies the right acquired to indemnity as specified in UCC 7-504 subsection 4. Additionally, the plaintiff designates the defendant as a secondary party based upon the definition provided in Black's Law Dictionary 6th edition. Here are the factual backgrounds. The plaintiff, Bezel Bay, serves as a duly appointed trustee of a legally established trust. The defendant, DEF Trust, is another trust entity that entered into a contractual agreement with the plaintiff. The contractual agreement includes a clearly defined arbitration clause that explicitly requires the resolution of disputes through arbitration. The defendant has failed to fulfill its obligations under the arbitration clause, thus constituting a breach of contractual obligation. As a result of the defendant's breach of contractual obligation, the plaintiff seeks a K-1 disbursement as a suitable award to redress the damages suffered. The plaintiff asserts that the defendant had a duty of care and was bound by the contractual limitations as mandated by UCC 7204. The dispute in question involves general intangibles as defined by Black's Law Dictionary 6th edition. The plaintiff seeks remedy for the breach of collateral as recognized and provided for UCC 2701, and furthermore the plaintiff asserts that the right to seek indemnity as remedy in accordance with UCC 5-115. The plaintiff also asserts that the right to reimbursement as prescribed by UCC 5-114. Additionally, the plaintiff claims the rights acquired to indemnity as outlined under UCC 7504 subsection 4. The plaintiff designates the defendant as a what? A secondary party based upon the definitions provided in the Black's Law Dictionary 6th edition. Here are the claims. The plaintiff claims that the defendant's failure to comply with arbitration clause constitutes a breach of contract or contractual obligation. Plaintiff seeks a K-1 disbursement as an appropriate award for the damages suffered due to the defendant's breach of contract obligations. What is the relief sought? The plaintiff requests that the arbitration tribunal, the plaintiff requests the arbitration tribunal to enforce the arbitration clause and grant a K-1 disbursement as an award in favor of the plaintiff. 2. The plaintiff seeks remedy for breach of collateral indemnity and reimbursement as provided for by the relevant legal provisions. Then we have the relevant legal definitions. So it breaks down, number 1, the duty of care. It breaks down contractual limitations. It breaks down general intangibles. It breaks down on demand. It breaks down registered form. It breaks down remedy for breach of collateral. Breaks down remedy of indemnity. Breaks down the right of reimbursement. Right acquired to indemnity. Secondary party. All of this by simply giving the model very specific instructions. First, I wanted the style to be used. I wanted to use legalese to describe the explanation. And then I laid out who the plaintiff was and what the plaintiff was seeking. And I let it run a mock case based upon the parameters that are set. To me, this is a very powerful tool, but it's not supposed to make you lazy. It's not supposed to just do everything for you. You got to have some information. See, I got to know about this case. Now, pay attention, because if you don't, you're going to miss something. I'm going to now go to my insurance manual. I think I'm going to share it in both spaces, so bear with me while I share this particular. Okay, yeah, it should be insurance and law right there. You're going to see this page where I got the insurance up here. And you guys are looking at it. The other ones in the other space, you guys are actually going to still see my my ChatGPT. So don't get lost. Just pay attention, because if you listen long enough, look long enough, you'll learn something. I'm going to pick this case right here. Double A Mutual Insurance Company. This is the case that I want to look up. Matter of fact, Ace Insurance Limited. This will be a better one, because I want to see this from this perspective. I'm going to plug this case into ChatGPT, because this case is what I want to research. So let's research this case. Paste it inside. I hit go. And it's going. Alright, now watch this. It says, I apologize, but I can't find any specific information regarding the case. Is it possible that the case reference you provided may not be accurate, doesn't exist, or may have a legal question? Or if you have a legal question, can I assist you? Watch this. Let's see. Please summarize. And I may have to do a different model. I'm just trying to see if I can use the same model to get me a reference here in this particular case. Okay, now it says it doesn't have enough intel about this case. Let's try to add a little more detail to the case by going here. And let's see if I'm gonna try it there. Bear with me. Let's see what I can get here. let's see. That one isn't giving me what I'm looking for. I'm trying to show. Let's see. Try this one. Bear with me. Guess we're trying to draw references here. Now watch this. Now I chose a different case, and now I'm getting a reference. And the case that I chose was this case right here. Akron and Shausha versus Policyholders Protection Board, 1993. It involves a legal dispute between Akron and Shire, the claimants and Policyholders Protection Board. Unfortunately, as an AI language model, my access to specific legal cases is limited, and I do not have access to the full text and details of the case judgment. However, based on the case citation you provided, it appears to be a reported decision from 1993 in the United Kingdom. The reference of 2WLR 475 indicates that the case is reported in Volume 2 of the Weekly Law Reports from that year, starting on page 479. To obtain a summary or analysis of this specific case, I recommend consulting legal databases, law libraries, and reaching out to legal professions. This will be better equipped to assist you with the specific details and analysis of the case. Now, watch what I do in this language. Now, I just simply said, I gave it a case number. Now I'm finna go into the same case. I'm gonna copy it, but I'm gonna put some different prompts in it. I'm gonna say write a case summary for write a case summary. Bear with me now. Let's just see what the model comes back with. Okay, now, since this case gives me that particular proponent, let me try to go a little deeper here, because I'm trying to give specific references. Now, if this case was heard in 1993, what was the decision? The legal decision. Alright, now let's go to a different, I'm going to try a new chat. Because sometimes you have to go into a new, I already was using this model earlier, and I'm trying to simulate, I'm trying to give it a certain response here. There we go. Let it refresh, repetition. Let's go here. see. Bear with me. Alright, come back. Let's go here. There we go. Different case. New model. Alright, I put this other particular case in. It gives me the citation that indicates the case was heard in the Court of Appeals in England and Wales. The neutral citation 201 is used to identify the case uniquely and is often used as legal research and reference. The law report citations refer to the volume number, alright, where the cases is published. Now, I'm pulling these cases because I'm looking. In the case of Martin versus the citation is as follows. That's a citation. Now, instead of the citation, let's just pull the case itself. So I want the case. And hopefully you guys who will be seeing this video is looking how I'm putting these searches in. Okay, it's gonna ask me. Okay. Those of you that are watching me put this in, just pay attention. Of okay, we want the full citation. So let's give it the full citation again. That's the full citation. Go back. Okay, here we go. Alright. So it won't give me full citation. Now, technically when I get here, what I will do is I will go to Google. So let's go to Google. I will use a search engine to see what references come up with this particular case. Let's see what we get here. And this is what happens. Okay, da 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 da. This particular case. This gives me some details on the case right here. This gives me the docket number, the case number, the date, the judgment, all right, the tort. This right here is the entire case. Now, all right, let's see. Now technically, let's see, how much is this thing? Let's see, how big is it? Oh, gotta go out of here. Let's see, I got the case and docket citation, jurisdiction, Court of Wales, practice procedures. Let's go out of here. All right. let's say, for laughs and giggles, I want to write a mock case similar, write a mock case, let's see, similar to Alright, let's get creative here. Write a mock case. Alright. Let's go here. Okay. Alright, here we go. Let's go back. Let's see. Let's see if I can try this. Oh, gotta use a different text. I gotta use a different set of rules here. Let's see if it'll do it. And here we go. Now, why am I showing you this? I'm showing you this to kind of expand your mind to the possibilities of being able to use these tools in a lot of different ways to get work done. I asked it to give me a case similar to the one I was looking for. Write a mock case similar to Bacardi Martini Beverages Ltd. Thomas Hardy Packaging. It says certainly here's a mock case that is similar in structure to the citation you provided. Now notice, I was asking for references and it didn't have certain information. But when I ask it to give me similar, make up a mock case similar to it, this is the results. I want you to see this. I don't know if everybody can see my screen. I want you to see that. It's giving me a similar, it's literally, let's see here. It's giving me it went ahead and populated a similar case. I asked it to write a mock case similar to Bacardi Martini Beverage Ltd. It says certainly here's a mock case that is similar to the citation. Now as I was asking it questions, I wasn't getting the results that I was looking for. Now if I had limited information, I would have stopped when it said I apologize but I can't, when it basically would just give me the case number and the year. But I continued to persist with giving it information and data that it can learn from to be able to produce the response that I'm looking for. Again, why am I showing you this? Because what's about to happen in the next day is that you're going to be approached by myself and my board with very specific questions pertaining to what you're dealing with in the aspect of implementation. And if you're not using these tools in a certain space, you're going to kind of be in your own way. Now, I could technically, based upon the questions that you guys give me, and a very specific set of parameters, UCCs, UTCs, and so forth, we can simulate a particular scenario and walk through it tick for tack in a spreadsheet format, in a presentation format, whatever is most applicable. At this point, I'm simply trying to make sure that those of you that are going to be heavily inundated with this information understand the potential, especially for those of you that already have materials. You have case law. Now, let me give you something that for those of you that actually have this, the English, the private English law manual. That's the big 14,000 page manual. There are special cases that you can't technically pull up, but because it's tied to a database, you can simulate. And if you can simulate them, you can utilize them. All right, now the gloves come off. Who in this class does not have access to some sort of hardware that can allow them to utilize ChatGPT? Press 9 on your keypad if you have no access to any type of device or hardware that could give you access to ChatGPT. So everybody that's in this class right now, speaking to me, watching me, listening, you have in some form of fashion access to something that can give you access to ChatGPT. Is that correct? Am I safe in my assumption of that? All right, because I want to make sure now. Let me unmute this thing for just a second. So I want to make sure I'm hearing everybody correctly.
All participants are unmuted.
Everybody's unmuted, so you have to mute yourself back. Am I safe to assume that everybody does have access to ChatGPT? Is that a safe assumption?
I don't have access.
Okay, who is that? Who is that? Jarvis?
Yeah.
Okay. All right. Most of your computers that you have at your disposal, what are they? Windows, Mac? What are they?
Chrome.
All right, Chromebook. I don't know whether Chrome will let you install a full version of ChatGPT. I'm only recommending that individuals use some sort of Linux platform because you'll get the better bang for the buck. I know some people are putting it on their phones and this, that, and so forth.
Go ahead, man. Go ahead. This recorded. This recorded. We can play. I can play this back. I can't play you back, baby. Well, just pause it then, sir.
Let me go ahead and take him and put him back in the mute, man.
All participants are muted.
At the end of the day, literally, there is a reason why I'm asking that you have access to these things. And one of the main reasons is that the ability to monetize, the ability to move forward with your awards, rest in your ability to contract. And by far, the ChatGPT tool makes contracting a non-issue. The only reason why things aren't being done is because they're not being done. Especially when you have the reference materials. Especially when you have the case law. Especially when you can take a case law that you have and actually allow a unit to actually describe the case as if you were a 3-year-old. There are so many different prompts that can be used in these tools. It's just a matter of implementation. But I'm not hesitant. I'm just a little how can I say it? I'm over here in the fast lane with individuals who were out of yesterday's class have already started offering students banking platforms to monetize their awards. And they're using these tools. You know, the ability to take it to a vendor or a lender like Go Capital and be able to get it monetized contractually. They're already doing that. We have individuals who are actually acquiring licenses like securities license, insurance license, and you know, various different things in their respective spaces because they're going to be very specialized in their level of contracting. Even with mortgages, one of my partners yesterday, he enlightened me to the fact that if we were able to convert equity into a promissory note, or what we call a perfected promissory note, or a convertible note, if you will, these things are actually being monetized directly off of the real estate investment side, all because of ChatGPT. The ability to acquire precious metals and then have it placed into a trust certificate unit. These things can be done through ChatGPT because it's all contracts. The ability to do trust minutes. The example that I just gave you earlier was by far, in my opinion, one of the best examples of what trust minutes should look like. It should have, in my opinion, those four parts, which I'll refer back to again for simplicity. We talked about, let's see. Yeah, when it gives you the outline. The outline consists of a case summary. It gives you factual background. It gives you claims, relief sought, and relevant legal definitions. This is what trust minutes, in my opinion, should look like. Then when you're actually doing noting and minuting your journal, you're just recording the time and date in very specific, or what we call highlights. Basically, it'll be just like this, but it'll have dates and times. Like, I'll just kind of go here. You see how they break this down where it says, in this arbitration case, the plaintiff, so when it says the plaintiff, Bezel Bay, seeks an award in the form of a K1 disbursement, that'll be dated. It'll basically say the plaintiff, which is Bezel Bay, relies upon the legal principles of, and this is just extra detail. When we talk about noting and minuting, you should associate noting and minuting to detail. And when you go into your notary journal, it should be like shorthand. It's the right to the point, date and time, who did what. Noting and minuting in your trust minutes should be detailed. The more details, the less room for scrutiny. And again, these tools that I'm describing and discussing, in my opinion, should be tools that should be made accessible. So I'm at a point now where if you have a very specific conveyance that you're looking to implement, one should be in a position when they can do so. Now, you're only as good, this tool is only as good as the information and data that you what? Induce into it. I took I kind of took a certain type of perspective because I wanted it to write it in a certain style. I wanted to use legalese in the description. Some individuals may not, and again, this is my preferred method because of what I'm authoring and what I'm issuing. If I want my language to appeal to bankers or accountants, I will give it a certain style and language. Typically what? Legalese. if I'm giving this to someone who hasn't been in trustee training, but I need to get my point across, I would basically take a very complex scenario like a particular case and summarize it, you know, in a different capacity. Like, let's see. Less for conversations. Write me a list of famous trust dispute cases. Write me a list Now, for those of you that can't see my screen, ChatGPT is writing these cases for me. Let's see here. You guys might not be seeing my screen. It's literally, I asked ChatGPT to write me a list. Write me a list of famous trust dispute cases. Certainly, here's a list of famous trust dispute cases. Marshall versus Marshall, a high-profile case involving an estate of J. Howard Marshall II and the claims made by his widow, Ann Nicole Smith, which sparked a legal battle over the distribution of estate and trust assets. Then in the estate of Marshall, again, it gave me Marshall versus Marshall. It gave me in reference to estate of Marshall 2010. Following the previous case, this case was involved over dispute of John Marshall II, subsequent battle between his son, E. Pierce Marshall. Then we have Kemp versus the Commissioner. This case involved a dispute over trust validity and IRS challenge in reference to the Lehman Brothers holding. These things, when you plug them in, it's technically giving you. And again, let me bring up this. How can I do this so you can see this? Because I want you to see this. Don't take my word for it. I want you to see this. Now you can see. I want you to see that ChatGPT gave me 10 famous cases. Now, we even have we have a Pinay and Roshner. This case involved a dispute over a family trust where the beneficiaries challenged the trustee's actions and sought to remove him from his position. The estate of Nina Wang, a highly publicized trust dispute in Hong Kong involving a late billionaire, Nina Wang's estate, where multiple parties claiming to be the rightful beneficiaries of her vast fortune. Then we actually have a Rothschild versus the estate of Hammett. This case involved a dispute over a trust created by the author, Dazelle Hammett, with his daughter challenging the administration of the trust and the handling of the intellectual property. Now, I asked ChatGPT to give me these cases. And once I have these cases, I have the study material in front of me. I can now begin to put together. When you hear those that practice arbitration saying they have actually heard, 8,000 cases, 2,500 cases, 500 cases and never lost a case, it's because in arbitration, you're agreeing with your adversary on your way to court because it's going to be handled privately. There's going to be an award. And as long as everybody stays within the agreements, there ain't no problem. Now, again, I asked for famous trust dispute cases. Now, watch this. Can you give me a list of famous trust arbitration. Watch this. I'm trying to show you something. I'm asking it to give me a list of famous trusts. Keyword famous. Can you give me a list of, now watch the response. Certainly, here's a list of famous trust arbitration cases. This list provides examples of famous trust arbitration, but it is not exhaustive, and there may be other notable cases that are not included here. Got Frank Sinatra, Elizabeth Taylor, the estate of Michael Jackson. Okay, now, and I want to just read this to you, because if you listen long enough, you'll learn something. In Carvalho, the Toll Brothers, and the developers, 2007, this case involved a dispute over trust agreement between the two real estate development companies, Toll Brothers and Canovo, which was resolved through arbitration. Deutsche Bank Trust Companies Americas and Unitech Limited, 2009, a well-known trust arbitration case involved a dispute over Deutsche Bank and Unitech Limited over a loan agreement and the subsequent arbitration proceedings to resolve the matter. Then you have Astro versus Lipto. This case involved a trust dispute between Malaysia Satellite Television Company and Astro and Indonesia conglomerate Lippo Group, which was submitted to arbitration for resolution. Then you had the estate of Maximilian Squirrel. In 2004, a trust dispute arose between the beneficiaries of the late actor Maximilian Cristelia's estate, and the matter was resolved through a trust arbitration proceeding. These are valuable tools, because if you were to go and research these tools, like, all right, we have the estate of Michael Jackson. After the death of the pop icon Michael Jackson, a trust dispute arose regarding the management and distribution of his estate, which was ultimately resolved through what? Arbitration. You have estate of Frank Sinatra. The estate and legacy singer Frank Sinatra faced a trust dispute among his family's members, leading to arbitration to settle the matter and determine the distribution of his assets. The estate of Elizabeth Taylor. Following the passing of actress Elizabeth Taylor, a trust dispute emerged among her beneficiaries. You kind of see where I'm going, right? I'm going to pause because I'm looking for questions on how to use these tools in a real world scenario. I'm hoping somebody has a question. Well, Mr. Bay, how can I, or what would you recommend, or is it feasible? I'm being as humble as I can and trying to help you, help me, help you in this aspect of implementation. But I need some input. Please press 9-4 on your keypad. That way I can engage you in conversation. Otherwise, I'm going to assume that everybody's getting this and they're just ready to rock and roll, and I'm just waiting for prospective dates to be scheduled for implementation. Based upon what we discussed up until this point and what I've just demonstrated in a short period of time, just with this one tool, because there are other AI tools besides this that we can get into, but there's no need going any further unless you have a clear understanding of the fundamentals. And with that, do we have anyone that has any questions? Any questions? Everybody's good. No questions. Okay. Finally, somebody will ask a question. All right, big bro, talk to me. I'm hanging, man. Uh huh. Yeah. Yeah. Right. The pr- right. Keep in mind the shepherdized cases you're going to have access to. The private cases, because you have the manuals, you're going to have access to because they're going to reference the cases in the manual. So it's taking. So you have the resource. So once you have the resource, you're just asking the model to give to reverberate what you have and give it get it helps you decipher the case, break down the case, to be able to use the case. Like this tool, you should be able to, with your trust manuals and the case references that you have, plug those cases in, take these cases completely apart, put them back together into a form that you can explain and break down to a 3-year-old and make it applicable in your structure. Right. 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 Exactly. Or you then you can say to write me an out you write me an outline on the summary. Right. See, there's different commands and prompts. So as you use these tools, you technically want that's why it's imperative that you have the reference tools because individuals who don't like to read and do research, they're just going to say, create this for me or do that for me. And they're not plugging in any up to date, relevant information. This tool is only as good as the user. See, understanding the model, it's designed to take language model format and repartition it into a particular style. That's why, like I'm looking, and you'll learn the prompts. Like for those that are in the syntactical trust, ethical hacking classes, they deal with Linux, they deal with these. It's easy to determine the prompts. You just have to look at what you're using. You can update your model. Like the model I'm using, it's a free thinking tool, but I've engaged with it in certain things, so it has learned the style, how I ask questions, what am I looking for. It's no, I'm going to ask questions 10 times, 10 different ways, and every time it engages, it learns. So you have to have a position of knowing. Like this tool can teach you what you think you already know. It can help uh, package those ideas quickly. This tool speeds up the research process, and it makes implementation instantaneous if you know what you want to do. Now, if you're still looking for, like again, if you need an outline, like I'm gonna kind of see if I can do this in real time. We'll take this Deutsche Bank trust case right here. It's a trust. It's a trust arbitration case. I'm going to say write a summary. Now I'm just going to give it just this basic instruction. I'm not going to ask for a style or anything. See what type of response I get from this. And it's giving me pretty good intel. I asked it to write a summary. Here's what it came back with. I said, write a case summary for Deutsche Bank Trust Company, Americas versus Unitech. Deutsche Bank Trust Company versus Unitech is a significant case involving a trust dispute between Deutsche Bank Company, Americas, and Unitech. This case revolves around a loan agreement between the two parties and the subsequent arbitration proceedings to resolve the trust dispute. In this case, Deutsche Bank Trust Company Americas, acting as the lender, had entered into a loan agreement with Unitech Limited, an Indian real estate development company. The loan agreement contained provisions that required any disputes arising from the agreement to be resolved through arbitration. However, a disagreement arose between the parties regarding the loan agreement and its terms. Deutsche Bank Trust Company Americas claims that Unitech Limited had failed to fulfill its obligations under the agreement, including the repayment of the loan. Unitech Limited, on the other hand, disputed the validity and enforceability of certain provisions in the agreement. As per the terms of the agreement, the dispute was submitted to arbitration. The arbitration proceedings were conducted to determine the rights and obligations of each party, the validity of the loan agreement, and any potential breaches or non-compliance. During the arbitration process, both parties presented their arguments and evidence to support their respective positions. Expert witnesses were called upon to provide testimony and analysis relevant to the case. After careful consideration of the evidence and the legal arguments presented, the arbitration panel reached a decision. The details of the arbitration decision and its specific outcome are not provided in the case summary, as it is necessary to refer to the original judgment or arbitration award to obtain that information. Deutsche Bank Americas Trust is significant because it showcased the use of arbitration as a means of resolving trust disputes. It highlights the importance of arbitration clauses in agreement and demonstrates how parties can resort to alternative dispute resolution methods to resolve their differences rather than pursuing litigation through traditional court processes. Now, that summary of that case can be made a cornerstone in any compliance officer's briefs, notes, in noting and minuting. You can now, because you have an idea of what happened between Deutsche Bank Trust Company Americas and Unitech Limited, it demonstrates why arbitrating can in a lot of cases be more favorable than litigation. It's a paramount case. Now, this is the reference that I just plugged in from just the list that it gave me. I'm now going to ask it to give me an outline. Write an outline. Now watch this real carefully. Write me an outline of the use of arbitration using this particular case as a reference. So I'm going to say write an outline. Write an outline describing the advantages, and I'm misspelling, advantages of using arbitration arbitration over litigation. I'm misspelling. Write an outline describing the advantages of using arbitration over litigation, comma, using Deutsche Bank as a reference. Yeah, got a little misspelling going on. Let's see what we get. And voila. We get an outline, advantages of using arbitration over litigation. They want you to, first you need to define arbitration, give a brief overview of the case. Then it goes into the advantages of using arbitration, confidentiality, preservation of privacy, non-public nature arbitration proceedings. It also gives you flexibility. Let's see, yeah. We go into, see, this was a pretty good outline right here. Flexibility and formality, choice of arbitrary process, flexibility. So in the aspect of the example that I just gave, you see how impactful this can actually be, you know, and when you're plugging in this information. Brother Antoine, can you see that? Mm-hmm. All right, beautiful. So this is taking the case from the list and then having it write an outline describing the advantages of using arbitration over litigation, using Deutsche Bank Trust Company Americas as a reference. So if you can think it, you can achieve it, and you can implement it. It's just a matter of just how you choose to utilize these tools. Anything else you want to ask pertaining to how we use these things in the aspect of implementation? Mm-hmm. 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 Yeah. Mm-hmm. The thing that I tell you to do, start training your models by working it. It's a workhorse. You gotta point it to something. You gotta give it a task. So when you do, you should, in my opinion, as compliance officers, you should have your own contracts put together, your own negotiable instruments put together. These tools make that a non-issue anymore. The pointers I will say are simple. If you're trying to learn how to take an M3 asset and position it where it can actually be used inside the court register investment system, we can start there. Like, give me a question that you're seeking an answer to pertaining to any of the information that we discuss. And I'm going to give you an idea that you can use ChatGPT to help formulate and simulate. Mm-hmm. Mm-hmm.
I would ask as far as the transmittal letter
Okay. You want to
in
know?
regards to okay, we've already established the fund. I've already acquired the insurances as far as being able to. That's what we utilizing as leverage. And now I want to be able to draw the transmittal letter in preparation of the money transmittal bond.
All right. So you want to.
That's another question. Okay.
So you want to draft transmittal letter. To be used in what? What do you want to use the transmittal letter for?
This particular transmittal letter is going to be able to acquire real estate, but the collateral is going to be from the fund.
To acquire
Credit enhancement.
to acquire real estate. Draft the transmittal letter to be used to acquire real estate and implement draft the transmittal letter to be used to acquire real estate and implement a money transmittal bond to be collateralized which you want financed. Financed. I'm having a brain fart. You want financed in the terms and conditions. Terms and conditions. Conditions of the loan by a lender. Alright, so I say draft the transmittal letter to be used to acquire real estate and implement a money transmittal bond to be collateralized at a 1% filing fee. At a 1% filing fee, which can be financed. I got a typo there, but this should work. Let's see what it gives me here. Let's see. All right. So here's the results that we got. I asked it to draft me a transmittal letter to be used to acquire real estate and implement a money transmittal bond to be collateralized at 1% with a 1% filing fee, which you can finance in the terms and conditions of the loan by a lender. Basically, it gave me the salutations, subject matter transmittal letter, real estate acquisition, and money transmittal bond. Dear recipient, I'm writing to formally request your assistance in acquiring real estate and implementing a money transmittal bond to collateralize the filing fee as specified in the terms and conditions of the loan provided by our lender. As you may be aware, we have secured financing from the lender for acquisitions mentioned in the real estate property. In accordance with the loan agreement, it is required that the requirement to collateralize the 1% financing fee associated with this transaction. We have opted to fulfill this requirement by arranging for a money transmittal bond. The purpose of this transmittal is to initiate the process of acquiring the real estate and implementing a money transmittal bond. We kindly request your expertise and guidance in facilitating this matter. Our intention is to ensure full compliance, terms and conditions, the loan, while adhering to all legal and regulatory obligations. Then it says, please provide and close all relevant documents to the loan, blah, blah, blah. Well, I'll read it because some of you guys are listening. But here's what I want to show you. This draft gives you just enough of a template for you to build on. And whatever it is that you're lacking or needing, you can repetition it from this draft. So if I was to use this as my template, I would copy and paste this, and then I would add the things that I need to add to it. The citations, the attachments. Can I see how I did that?
I do.
Okay.
I got it. Okay, now let me ask another question.
Mm-hmm.
Because clearly contracts can be drawn up, it's no set.
Right. Right.
Set thing.
Right.
Okay, so is there a set requirement when it comes to when we're ready for the transmittal bond, or does that just the same apply?
If you're authoring the implementation, you're the author, so you set the rules. So you come in with a certain set of rules, and then you just build around it. Right, the bond has a language. Like you can. This is why you want to pull cases that reference money transmittal bonds. You want to get the research. Like, in order for you to be able to do what you want to do, you just simply have to think it, articulate it, write it down, research it, and use these tools to go in whatever direction you want to go in that direction. That's the power of that tool. So we can get off into many different reference points, but that is based upon what you know you want to use. In trust, I use what's relevant to the trust. I'm not allowed to have M3 assets in the hand of a non-competent fiduciary, so that'll be a part of my transmittal bond. I'm going to lay out the rules that it's going to be processed through the local court. I'm going to put the instructions in the transmittal bond. Like, I'll draft a transmittal letter that basically states that once you receive this package, you are to follow the instructions and get with the clerk of court for implementation. Put all that in the letter. Are you following what I'm saying when I say that? Mm-hmm. Yeah. See, you got to remember, these tools let you be the creator. And this is where a lot of people who aren't used to creating, they get lost in the sauce. They don't have no reference points, so they're looking for somebody to give them a direction. All you looking for is who needs what. I need to fill in the blanks with, because I know the process. It's going to be a K-1 disbursement. It's going to be a tax credit. It's going to be equity in an insurance policy. Once you know what you're going to do, it's just creating a form that everybody can attach themselves to, and implement. Right. And see, I love it because it makes contract writing for me easy. I simply try to keep a piece of paper engaged where I can jot down ideas for contracting. And then I do the heavy lifting. I go pull the cases. Even with 4 or 5 different chat bots up doing, making the language break down faster, I still pull a case and I read it. This tool just lets me do that in a much more faster capacity. When I want summaries, when I want, high points, when I want to create an outline. You got to remember, symmetric information, the public don't want to read. They want to be told what to do. And this tool can definitely be used to tell everybody who don't want to read what to do. Right. That's the prompt. Right. That's why you take a subject like let's say you used to be in the restaurant business, so you're a great chef. So okay, you know what it takes to cook the perfect set of ribs. We're gonna use that's the concept. Now you want to come up with 300 ways to cook those ribs. And this tool, if you say give me a list, give me 20 ways to cook ribs, then give me an outline on the top 10, and it's only as good as its user. But every time you engage with it, it learns. It learns what you're looking for, because you're going to get, the more you touch it, you're going to develop your own references. And that's what you want to do. You want to you learn, like when I listened and watched a tutorial a few days ago with legal professionals using chat, and I realized you could change the style. So I can have it give me this explanation as if you was a lawyer or an accountant. I can change the language, so it could style it as if you're coming from an accounting perspective. It could style it as if you're coming from a lawyer or broker perspective. It can style it if you're a 3-year-old. You follow me? Right. Right. Let's give you an example. Now I'm gonna take the same example that I just used, draft this transmittal letter. So I'm gonna go here. I'm gonna copy this again. But what I'm gonna do is I'm gonna add this prompt, and this prompt allows me to use. I'm gonna say, okay, I'm gonna go here in the bottom right here. But I'm gonna put in parentheses Alright, so I'm gonna put, let's see where I wrote it down. I'm trying to use my model without having to go, well, I gotta go back. Let me go back because I got it here. You're gonna see my prompt that I use, and this is something I learned from using this, that every user is going to develop his own way of using the style. Let's go here. I am going to tell it to write it in the form of legalese. Here we go, right here. Voice and style guide. I'm going to copy the voice and style guide I want it to use. Now the only difference here is that I've got a voice and style guide say use legalese to describe the explanations. Now I'm finna run the simulation again. And now I'm gonna watch it go to work. Now the difference in the letter that it wrote before and this one is the style. Because I told it to use what? Legalese to describe. Okay, now this is the new letter using the style that I preferred, and this is the previous one. So as you look at the previous one, it says I'm writing to formally request your assistance in acquiring real estate and implementing a money transmitter bond to collateralize the 1% fee as specified in the terms and conditions of the loan prepared by our lender. That's the first paragraph. Now let's go to the new one and read its first paragraph. Its first paragraph says, I hereby transmit this correspondence to initiate the process of acquiring. See how the style changes? Right. So those prompts let you critique how you want to say what you're trying to say. And when it comes to contracting, this is the thing, in my opinion, that lawyers will have to do a contract. It'll take them a month, sometimes 2 months, because it's all about the style and the usage. This tool just makes it easier to get your ideas out faster. And that's a prompt that you can use in your response. So it's about engaging with the tool. You have to assign it a specific task. Because you're dealing in asymmetric information, you got all the tools. You just got to use those tools to really dig into how to do certain things because it's in there. There's also another one called ChatGPT. Not ChatGPT, but ChatPDF. ChatPDF lets you upload your books. You can literally take your book that you purchased and upload it into an interface like this, and now you can sit there and ask the book questions. And it will say in reference to page 55, this, that, and the third. Reference to page 400 and such and such. This is huge because once you have asymmetric information, that's your reference point. You can dissect this thing however you want. That make sense to you? All right. Any other questions, comments, or concerns from anyone pertaining to these tools that we're discussing and the ability to use these to leverage, to implement? This is where the gloves come off. I want you to ask questions while you have the opportunity. There is no such thing as a bad question. I assume when I have no questions, everybody gets it. So I'm kind of like, okay, well, we're ready to rock. What are we getting ready to do? Again, is there anyone in this class? I think Brother Jarvis said he doesn't have access to ChatGPT because he's using Chrome. But let's see if I can bring him back on because I got a couple of questions I wanted to find out. Brother Jarvis, you there with me, man?
Yep.
Oh, okay. All right. Have you? I don't want to blow up your spot. There isn't an app or anything that you can use with Chromebook to install ChatGPT. I'm asking.
Well, I can try. I didn't.
I don't.
That's gonna get the one preferred.
Right. I would. Yeah, get with me and get the preferred one because I don't want. Because there's a reason why I'm finna say what I'm finna say. There is a lot of people, business owners, freelancers, contractors. Everybody is using ChatGPT to generate money with YouTube algorithms. It'll keep your views up. You can monetize. You can make money with it. Everybody is using this virtual assistant, if you will. But the key to this thing is if you're using it, what are you referencing? What type of prompts are you using? Um, I went through a series of prompts to demonstrate that if you don't know what you're doing, you're going to walk away different than somebody who knows what you're doing. Like, let me give you an example. If you were an author of a book, I know when I was in college, before they had Grammarly and so forth, you got to be careful of when you start getting answers off the internet, because you could find yourself flunking out because of plagiarism. Watch this. This AI ain't no different. A lot of folks don't realize that if you take something that just generically is created out of ChatGPT and just start using it without implementing a certain proponent, it could send off certain triggers on certain things. There is an algorithm to see whether or not this was a ChatGPT created response. Now, this is why I encourage you as compliance officer to use ChatGPT to speed up, cut down your workload of getting the ideas on paper. But what you're going to have to do is what? Once you get it where you want, you're going to have to touch it and make it your own. You got to put your own, swing and pizzazz on it. You're going to have to remix the content. So it makes, see, when it's yours, I can't take it away from you. Nobody can tell you whether it's right or wrong, because you're the one that, only the author can testify to the validity of the contents of any book that he or she is authored. Plagiarism gets you in trouble and you're infringing on copyrights. You'll notice I had to ask the model the same question 4 or 5 different ways to get the desired response, because I was looking for what? Symmetry. I was looking for an ability to have a basic template for me to build and create. I didn't want to simply just plug in, write me a draft, and then publish the draft. But you know how many people are actually doing that right now? And when you start using this tool, you'll see it. Mm-hmm. Right. Right. That's the key. It's a tool that takes your content to a whole nother level, and it gives you the ability to turn around, your research very quickly. A lot of times I'll have individuals that'll say, Mr. Bay, can I do this and can I do that? Now, I kind of went through the long way of showing you how to do mock cases. Well, wouldn't it be easier for you to say, Mr. Bay, I ran a mock case and this is what it simulates, and I want to use this case in my remedy. Now you see how that works? Now we're cooking with something. Now we can talk the language. Now we can turn all the way up. I got something to work with. You literally took your situation and put it into a mock case with desired remedy. Now you're doing what? Every time we engage back and forth, we're perfecting it. And the format is already laid out. I want to use my award to acquire real estate, but I need a contract. So I ran this mock simulation and this is what I came up with. It's like me checking your homework. I see what you're working with. I can engage. That's why I'm very reluctant to try to say the same thing over and over again. Even though I do, I try to say it different ways. I don't want you sounding like me. I want you to sound like you. These tools, in my opinion, you shouldn't be running from them. You should be spending an hour a day learning what type of AI tool can make what you do easier. What is something that notaries and compliance officers can do that none of this AI at this moment can do? Mm. Listen to how I'm saying this. This is what I want you to like. This is homework. If you can come up with 10 things that a compliance officer slash notary can do that AI can enhance, you are ahead of the class. Follow me? See, right now, AI to a lot of us, I'm kind of like a little, I'm a semi geek in one regard. To us in the tech space, these tools are open source, open to anyone who wants to use them. What do you think is going to happen when somebody come up with an idea to put a price tag behind one of these AIs? I'll give you one. What if you could go to Jarvis's compliance officer training's website, and he has this little bot called Ask Jarvis. So you ask Jarvis a question. Jarvis, how can I monetize my arbitration with a K1 disbursement? All it is an AI. He just call it Jarvis. But you got to register to go to his site. Follow me? But what if all of right? What if Jarvis has stockpiled his model with all of the cases that he has what? Arbitrated. Now it makes sense to go to his spot because he's got the case law and references to what? To back it. I can't get that anywhere else but in his space. See all these different niches that are getting ready to be created with the right opportunity? A question came up today. If they're no longer teaching cursive in college and school, how on earth is a young man or woman able to endorse or sign a contract if they don't know how to write manuscript? Remember, mobile notaries and signing agents, that business with notaries boomed during the what? Pandemic, when everybody was not allowed to what? Frolic and congregate.
Artificial intelligence giving jobs itself. It's creating jobs.
Right. It creating jobs for those that can use the tech to do their job more effective, more efficient. So the homework is come up with about 5 to 10 things that you can use this AI to enhance your ability to be a more efficient compliance officer. Like, they're just low hanging fruits that are all around. How many of you guys have ever gone through a loan process?
Yes, sir.
What if you can go through a loan process controlled by AI, where you can get an instant approval while on screen? What if someone can come to you as a compliance officer and plug in a scenario, a mock case, and you determine whether or not it has merits for arbitration? And if so, you can immediately contract with that individual and bring them into the space to get them a remedy. Can all that be done? What I just showed you with this tool? If you ever looked at the notaries in its entirety, I was sharing with a fiduciary today in the small town where I'm from. When I was on my vacation, there was this lady who, in that county, they only went to court every 6 months. That's how small this county was. They held court every 6 months. So if you didn't bond out of that county jail, you was stuck for 6 months, minimally. This lady decided that since she was a notary and she was in these counties where the circuit court judges rotated from county to county and they were going in that capacity, she created an opportunity where she could technically, do all these things, in under her own merit. So the long and short of it is, this individual contracted with the local sheriff. The local sheriff decided that this would be, a pretty good idea. And lo and behold, they were able to, it was like mobile notary before mobile notaries became a thing. See, when you're posting a bond, it's what? A contract. Somebody's putting up property, and there's a promissory note, and you're agreeing to appear. She literally went to those counties, passed out business cards with her toll-free number on it, and if you were brought in, you were guaranteed to get out within 24 hours if you called that toll-free number while you were on the phone or your loved one was on the phone. If they had access to a computer, smartphone, or so forth, she could DocuSign you all of the bonding agreements. It was a DocuSign that the sheriff already had them rubber stamped. But she literally sat at home and she was running a bail bondman / notary business from home, working 3 counties because the court system is what? So slow. Now, I learned a lot about the bonding process because a lot of the documents, because as a trustee, I was able to see a lot of stuff that everybody else wasn't able to see because that's a perk of being a trustee. And all she was doing DocuSigns. But I didn't see one bond that she did where she didn't make $2,500 to $5,000, and she was doing like 5 and 6 of these things a day on the weekend from home. So I got to thinking, if someone who's a notary can exploit a niche with the court register investment system like that, then imagine what a competent fiduciary who has these AI tools can do. If you were doing process serving and you had to put together a transmittal letter, and it only took you 5 seconds to put a draft together with this type of tool, and the courts paid you $125 a document to serve, how many you think you can do if you can do them in 5 seconds?
How many they need now?
Now, every person who is a notary in their prospective states, you can call your local clerk of court and find out whether or not their county allows private contracting for process serving. And if they do, just like the young lady who passed out her business cards, you just need to send them something in the mail. Hell, drive by, drop a business card or package off, get on the list. Remember, there's counties, just like the county I'm from, they only hold in court every 6 months because they only got a limited amount of judges to go around. Those are the type of niches where what you're doing comes in handy. What's the next big holiday coming up? According to the Gregorian calendar, what's the next big holiday coming up? There you go. Juneteenth, 4th of July. Imagine these small towns and small communities, most of their revenue come from what? Traffic violations, moving. I'm just saying, I'm not saying, I'm not telling nobody anything they already don't know. I'm just saying if you're a notary and you're trying to figure out how to earn extra revenue and this, that, and the third, your notary stamp can do a whole lot. Your ability to do noting and minutes can do a whole lot. Your ability to reinsure, bond, and implement sureties can go, in a lot of different directions very quickly. But definitely, Jarvis, if you're ready to go ahead and crank up and maybe grab your unit, reach out to me. You got the new number to the office, right?
Yes, sir.
All right. Reach out to me because we got some in. I just need to just find out what you need and get it shipped to you.
Okay, great.
Anyone has any other questions, comments, or concerns? If you do, please press 9 on your keypad.
Do we need to contact the courts in our specific counties in order to find out like the formats of the money transmitter bonds, or is there a standard? Because I was just listening at you just now
Right.
with the notary,
Mm-hmm.
and it pretty seems like simple standard information.
Yeah, what you literally do is if you're going to provide sureties and you want to, like, here's some homework. Notaries, look up in your area what does it take for you to become a bail bondsman, and you're going to learn something about the notary process that's going to like jump off the page. I give you something that a fiduciary use. You know you're going to need some property in order for you to work in the aspect of bail bondsman. But bail bondsman is simply having that equity in the form of a bond or a surety and being able to have the sheriff hold it as collateral. So really it's a contract. It's equity that's in some real estate, whether it's in the county or out of the county. The sheriff prefers the property being in the county. But if he has a private contract as a bail bondsman, they have a certain amount of insurance. So let's be real clear. You know, like in business, you got to have a general liability policy, right? So the sheriff gets a piece of your general liability insurance. He holds your general liability. And then you get to make all of the other funds, for bonding that person out of jail. You make all those fees. Now, when they don't show up for court, now the sheriff is foreclosing on your general liability insurance. And of course, if he file a claim on your general liability insurance, you ain't finna be a bail bondsman too much longer. Or it's gonna be very expensive because you got all these claims. Get it?
That's why they be on the hunt.
Right. Now, there's a way, if you understand all the stuff we're putting down, if you're a notary, if you have utilized the bond in one case, there's nothing stopping you from monetizing it in another case. You just have to contract a certain type way. Like, they may have this clause where you got to have 3 times the equity. You got to have 3 times the amount of the bond in equity for them to use the property. So if they got a $20,000 bond, how much equity they want? 120 grand, right? What if you can give that to them in a surety and a money transmittal bond? You don't think that sheriff will rock with you? Right. I'm just saying for laughs and giggles, if you had a judgment certificate for a $300 million indemnity bond, should be pretty easy for you to start a small bonding company.
Right, and that's what I was asking just then about the format. Okay, what is the expiration on these phones?
Well,
Where is that?
that's why you want to check. See, that's why you get in, use your tools, and you'll be able to research, the various different links and so forth. Because there's different, how you say, different stroke for different folks. There's a bond for very specific things, and these type of bonds could be specialty bonds. You know, for trucking, you have a surety bond. It's a specialty bond for brokers. Brokers, you have a surety bond for those that just pursuing a certain type of authority in trucking. So all these things, you want to research prospectively. But it's not hard to induce. It's not hard. Any other questions?
I got a question. It's
Mm-hmm.
not directly talking about,
Mm-hmm.
but it's a question under that.
Mm-hmm.
When we um, when we set up additional special purpose vehicles, subsidiaries,
Mm-hmm.
what are the what are the unique identifiers that's required for that? Because I know that everything isn't gonna, you have private numbers as well as public numbers. So I guess my question would be, is knowing which one to use when.
Mm-hmm. So, so the question is, what?
When you're establishing special purpose vehicles or additional subsidiaries, even a discretionary trust, the
Mm-hmm.
identifiers that go along with those. Um, I guess my question is, how do we put the identifiers on those? Because I know everything isn't going through state. Everything doesn't have to,
Mm-hmm.
because when you go to put it into the public space, then it's no longer private. So it all depends on what we're doing.
Right.
So, but just from a normal structure. So right now, if I go to the 15 structure, of course, we got the master of the home and the auto. So
Right.
now when I go to the next layer, which is I believe that's the management trust, the business trust, and administrative trust, if I'm not mistaken.
Right.
So now with those, with the subsidiaries, the trust that or discretionary trust that will establish, that because I created a discretionary trust to do an acquisition
Mm-hmm.
that's tied to um, the main trust.
Right.
So what unique identifier would we have to give to that that it's just for this transaction?
Mm-hmm.
What does it need?
It.
Is that required?
What best way for me to respond to that is, if you want to use one, author one into the trust bylaws and declaration. If you don't want to use one, then you don't have to specify that in your trust res. What's applicable? See, the DTCC and DTC exists because individuals that dealt in securities, that system became automated to control the commercial paper. See, at one point, everybody was walking around like the monopoly man, like the monopoly guy, with stocks and bonds in a briefcase and in safes. Then corporations and CEOs and CFOs got lazy, and these things got placed into a digital format. So the DTC and DTCC started collecting a physical paper and started issuing everybody these additional identifiers outside the QSIP system. Now you have an LEI and global LEI that has replaced the individuals that have the physical paper. So let's talk about it in symmetric and asymmetric terms. Asymmetrically, if you physically possess the paper, it's about what you want in terms and conditions on how someone can attach to your paper. I'm going to say that, I'll repeat it. Technically, what you want to look at is if you have the physical paper, if you have the physical specimen, that is the foundation for what you create digitally. See, the DTC and DTCC was created to remove those brokers that was holding commercial paper. This was a way for them to acquire the substance. Now, this whole cyber world has been operating around digital, a phantom system, if you will, a pulse and an image representing something of substance that was once real. And that algorithm is going to continue to promote the simulation of reality. If you physically have the trust certificate, you can write additional pieces of paper against the original. So the more original the substance is, the easier it is to create derivatives from it. The DTC and DTCC just did that with securities. This is why you have CUSIP numbers. This is why you have LEIs. This is why you have global LEIs or GLEIs. So one number works with you in a securities perspective, which is the LEI, the legal entity identifier, and then you have a global legal entity identifier because they have been selling the rights. We'll just call it what it is because this is not over you guys' head. They monetized the citizens because the country was broke and they owed the bankers, and they created a digital system to keep track of their property. And the LEI and GLEI is just the extension of the tracking system. If you got a 9-digit identifier like a social security number, that's a tracking number. That's an identifier. If you got an EIN number, that's an identifier. That's a 9-digit identifier. If you got a tax ID number, if you got an insurance policy, if it is more than 9 digits, this is an identifier. 99% of most of the things you use in commerce is affiliated with some sort of account and or number. Now let's make that. Now I'm giving you asymmetric. So asymmetrically, if you have one of these red receipts from the post office attached to the physical specimen, isn't certified mail receipts, registered mail receipts, securities? I'm going to unmute everybody because I'm going to get their response on the recording here.
All participants are unmuted.
Isn't, okay, good deal, beautiful. So if you know that they are securities, then it's just a matter of just making sure that everybody understands that from that perspective. Yeah, as long as they understand it from that perspective. See, it's not hard to get your hands on substance when you know where to go as a compliance officer. I'm staring at a certified mail receipt and a registered mail receipt. Yep, it has 9 digits on it. It's a 9-digit identifier. That's a bond right there. The red font registered mail is a bond. The certified mail receipts, they have more than 9 digits. That's a trust account. And both can be used synonymously. Postal money orders are actually backed by gold. So the instrumentalities aren't hard to get your hands on for a substance. It's just knowing what it means symmetrically and asymmetric. Symmetric information is what they publish in books. Like when the IRS says don't do this and you can do that, that's symmetric information because they published it. It's for the public. It's amazing how many things we engage in with all this symmetric information at front that we don't read, and then we're wondering why we're not getting the desired results we want. It's almost like you bought some flip-flops to hang up a painting. Now they're pretty flip-flops, quote unquote. You might like green and purple, but there's a perfectly good hammer that's designed to do that job. But some people like hanging up paintings with shoes. Mm-hmm. So it's just a matter of lining it up. Any other questions for me, big bro?